I'm here to present two bills dealing with the second injury fund. The second injury fund was created to encourage Missouri employers to hire injured veterans returning home after World War II, many of those that suffered injuries in the war, by shifting the risk away from employers from a workers' compensation perspective when an employee suffers a second injury. SIF is funded by a surcharge that employers pay on their workers' compensation premiums, and the second injury fund has a number of financial obligations from claims that have already been litigated and will have further obligations from a backlog of nearly 28,000 claims that are pending. The fund is, if not insolvent, nearing insolvency, and we're faced with a scenario where these obligations will need to be met, and there's a real possibility, because there has been a case filed in federal court that a federal judge will decide that those obligations will have to be met with payments out of the state's general revenue fund. This is a very real, very pressing, very time-sensitive issue that requires a solution. Senate Bill 430 and Senate Committee Substitute for Senate Bill 420 offer two possible solutions to this problem. Senate Committee Substitute for Senate Bill 420 dissolves the second injury fund and places those second injuries back into the workers' compensation system, though the current surcharge, which was mentioned earlier, 3% on the premiums, would need to remain in place. It probably would be up to close to 20 years before those current and future obligations would be met. Senate Bill 430 maintains the second injury fund, but would further limit access to the types of injuries that have access to the second injury fund, and provides a short-term cash flow mechanism that will allow awards to be paid and settle or adjudicate cases filed under the current law.
Whenever I started working with the Chamber a few months ago, I was laid this challenge before me to try to figure out some way to solve the problem that is the second injury fund. And to do that, it is quite apparent that you have to either limit what claims reach the fund or eliminate the fund. And because of that, we went through the analysis, and there needs to be a cash flow mechanism to get through the approximately 28,000 cases and the 700 cases approximately that are filed every month into the second injury fund. As Senator Maris mentioned, the funding is 3% of workers' compensation premiums, and that was based on the 2005 Senate Bill 1. 3% has historically been a level that would adequately fund the secondary injury fund in whole. However, based on the 2005 reforms to the workers' compensation system, the premiums since that time have dramatically fell, which in turn causes the second injury fund's premiums to dramatically fall. As an example of that, in 2009, $53.3 million was the revenue stream for the second injury fund, and in 2010, it was slightly below $41 million. So in 1 year, we dropped over $10 million. Also contributing to this is high employment rates, as the fact that there are less employees out there, there are less employees who pay premiums on, which also hurts the revenue stream. The second injury fund is a broken system where expenses are approximately 2 times the revenue stream, and injuries which access the fund are far beyond the original purpose of the fund. As a result of the broken system, the fund is bankrupt, and there is currently a federal lawsuit to compel financial resources to pay for awards, which currently equal approximately $920 million of current and future liabilities. I am confident that if the legislature does not act this year, the awards that have been adjudicated will be ordered to be paid for by either the employers by erasing the 3% and having that number flow to whatever is adequate to fund the awards, or that 3% will remain, and because the state of Missouri has found that 3% is an adequate level for employers to pay towards the second injury fund, that the general revenue fund of the state of Missouri will be that.
If I could, so you don't have a preference 430 versus 420?
If we could know right now that both bills or then we don't have a preference. We are taking a temperature of what we believe the political reality is, and we are fearful that a complete elimination, dissolving the fund, may not be politically feasible, and we would rather fix the fund and get something through than not get anything through and continue to build up 700 cases under existing